Can you
Yeah,
guys?
you're audible.
Okay, fine. Thank you. So today we will be doing this class on how to file a petition before this thing NCLT. Let me just share my screen. Just give me a minute. Right. So today we have to look into how does the creditors, they file insolvency petition before NCLT. So one of the method is like even, I mean, there are three type of people who can move and file this application. First, as you know, is the financial creditor. Second is the operational creditor, and finally, it is the corporate applicant who can go and file this petition. Now, as far as this petition, filing of this petition is concerned, there are certain things that you must remember, right? So if it is a financial creditor, as you know, what you have to do is uh, what you have to remember is, first, you don't have to serve any notice, unlike you have to do it in the case of your operational creditors. So as far as your, just 1 minute, this slide is, just give me a minute, please. Now, first thing that we have to look into is the locus and jurisdiction where you can file the petition. So, as you know that there are, I think now there are 14 NCLTs after Jaipur NCLT was operationalized, and you have a principal bench of NCLT at Delhi. Now, the place where you can file this petition for insolvency is where the company's registered address is there. So wherever the company is registered, wherever the corporate debtor is registered, then at that tribunal you have to file this petition, right? And very importantly, section 63 of the IBC, it provides that civil courts will not have jurisdiction to entertain any suit or proceedings in respect of any matter which the NCLT or NCLAT has jurisdiction under the IBC. And as you know, the default that is there, the threshold for the default is 1 crore rupees. It was initially 1 lakh rupees, but then it has been increased to 1 crore rupees, right? So under the code, who can file this insolvency petition? So you can see that it can be filed either by the financial creditors or operational creditors or by the corporate applicant. And the second thing you have to remember, that default must be at least of 1 crore rupees before one can file this. Now, as you know, who has a locus standi to file this petition, these application before the NCLT, you also need to know who cannot invoke this jurisdiction. So the first in the series is a corporate applicant who himself is going under CIRP process, right? Suppose there is a creditor of a bank who has against whom the bank has brought the insolvency proceedings, right? And the corporate insolvency procedure is ongoing, and it owes, the other company is owes large sum of money to ABC. So in this case, can ABC initiate the corporate insolvency process against the third party? So let me explain you again. There is a creditor bank which has initiated insolvency proceedings against ABC Corporation. Now the CIRP process against ABC is ongoing, right? Then PQRS is another company which owes large sum of money to ABC. Now, can ABC initiate CIRP process against PQRS, right? So if you look at this, then if you look at section 11 of the code, then ABC is the corporate applicant, ABC is the corporate debtor, which is already undergoing corporate insolvency resolution process, right? This is something that it is already doing. So there is an embargo upon it, that even if it owes large sum of monies against PQRS, then also it cannot initiate proceedings against PQRS. Now, why do you think so that this embargo has been put upon? Let us try to make it more interactive. So, when the companies are going, anybody would like to answer? You can unmute yourself and you can answer. So the answer to that is because once the CIRP process starts, then the moratorium kicks in. When the moratorium kicks in, then you cannot initiate any legal proceedings against a person, and hence the legislature has correctly, in its wisdom, has put this embargo upon the corporate debtor not to get sued or not to sue or get sued. So this is an important thing that you must remember. The second thing that you need to remember is a corporate applicant within 12 months of completion of corporate insolvency resolution process cannot invoke the jurisdiction of tribunal. And the third category is the corporate applicant or financial creditor who has violated any terms of the approved resolution plan in preceding 12 months. He cannot invoke this jurisdiction, the jurisdiction for invoking CIRP process, right? So the reason is, if you are the defaulter, if you have not respected the resolution plan, the approved resolution plan, if you have violated it, then at the same time you will not be allowed to go in for insolvency for another entity, right? So this is something which essentially gives the sanctity to the CIRP process. And finally, if there is a corporate applicant in respect of whom a liquidation order has been made, then this person cannot move for CIRP. The reason is, once the liquidation order is there, corporate applicant is bankrupt, and in such situation, he cannot initiate the insolvency resolution process. I hope this is clear. Now to start with, we'll take the first category, which is your financial creditors. Now, as you know that for the triggering CIRP, the threshold limit for default is 1 crore rupees. So, how do you initiate it? As a financial creditor, what you have to do is, as a financial creditor, first you have to make the complete list of the things which you say that this is how this person has defaulted. Then you have to collect the documents for each and everything which will substantiate your claim that this person has defaulted. So in this you have to first collect the relevant documentation, right? And at the same time you have to check into information utility of the which is an entity there, if it is provided. Now another way to check is, like, suppose the company, generally what happens is that for as a financial creditor, it is the consortium of banks which provides the debt. Suppose a person needs 50,000 crore rupees of a loan, right? So one bank cannot provide it. Usually they form a consortium and then they give this amount. Now it is not necessary that, suppose there are three banks, say PNB, Bank of Baroda and ICICI Bank. There is no default in payment of ICICI loan, but ICICI can initiate insolvency proceedings against this corporation if it finds that it is going in the financial distress. And how will it know? It will know it is going into financial distress when it realizes that it is not able to pay the loans taken by this person against PNB or Bank of Baroda. At the same time, one very important place where a person can gather information is your MCA's website, Ministry of Corporate Affairs website, where by knowing the corporate debtors number, whereby knowing the corporate identification number, you can have the complete data regarding the company, what are the charges it has formed, how is it doing, whether it has defaulted or not. And this is the basic thing. When you go for the paid version, you will be able to get far more things than this, right? Now, the persons who has been notified by the government to file this CIRP as a financial creditor, right? It is not only the financial creditors who can start, but the act says that that not only the financial creditors but also any other person on behalf of the financial creditor, as may be notified by the government, can file an application for initiation of CIRP against the company or LLP. So the government has notified this person who is a guardian of the creditor, a person who is executor or administrator of the estate of a financial creditor, if there is a trustee, including the debenture trustee, a person who is duly authorized by the board of director, they are the persons who can deposit this amount. Now, you will see that there was a problem with respect to home buyers. So there was with the subsequent amendment, a class of creditors was created. So there are home buyers as well as companies takes deposits also from public. Now, in case where there is a financial debt is there, it is in the form of securities or deposit. An application for initiation of CIRP can be filed jointly by not less than 100 of such creditors in the same class, or 10% of the total number, whichever is less. So suppose there is this company, say ABC, it has issued these deposit, and there are, if you want to challenge it, even if you are a single depositor, right, and your default is more than 100 crore, more than 1 crore rupees, then also you will be requiring 100 of such creditors in the same class, or not less than 10% of total number of creditors in the same class. Suppose it has issued this deposit to 20%, then 2 persons will be required to do that. Then second, we come to the class of creditors. Now, under section 21, subclause 6, capital A, and the subclause of that is subclause B, it has defined what do we mean by the class of creditors. So, in the class of creditors, an application for initiation of CIRP can be filed jointly by not less than 100 of such creditors in the same class, or not less than 10% of such creditors in the same class, right? So again, this is something which this person can do. Sorry. And finally, you have the case of home buyers, and again the same thing will require 100 of such allottees in the same real estate project, or not less than 10%. So emphasis is on the real estate project. So if there is a say there is a Supertech has got 10 different projects going on. So only from that one particular project, the person has to come. Now, in case of application which is to be made jointly by financial creditor, they may nominate one amongst them to act on their behalf, right? Then your next task is to gather the information. So for that, I have told you, you can look into MCA website, get the corporate identification number, and you can get the information, right? So after you move to the collected document, then you have to actually file the petition. Now for this, the relevant rules are IBBI Application to Adjudication Authority Rules 2016. Now these rules, 2016 rules for application to adjudicating authority, along with rules 22 to 24 and rules 26 of NCLT, are relevant. And as always, you must always check the latest amendment done to these acts. Now, first thing, you have to file an application. So the relevant form is Form 1 under the IBBI Application to Adjudicating Authority Rules 2016. And these rules are to be read with read with rule 4, right? And form 1 you have to fill in. So the financial creditor files an application for initiating, and what all should entail in this form. So this form must have the record of the default of the corporate defaulter as recorded in the information utility, or such other record or evidence of default as may be specified from time to time. So government keep on doing amendments, so you must always check for the latest amendment, and the best place to do is the website of IBBI. Then it should contain the name of the proposed interim resolution professional, and for this form number 2 appended to this 2016 rule is there. So in this person who is a proposed IRP, he has to say that as far as he is concerned, there is no disciplinary proceedings which are pending against him, right? And at the same time he has to say that he is willing to go for this. So this form number 2 will also be appended. Then you have another rule which says that IBBI insolvency resolution process for corporate persons regulation. Now by this regulation 2A is inserted. So the financial creditor is required to follow record or evidence of record. So what all you have to prove? So you have to provide certified copies of the entries in the relevant account in the banker's book, a court order or an order of tribunal that has been adjudicated upon the non-payment of a debt, right? Where the period of appeal against that person has been applied. So when you filed it, the application, you have to give the name of the financial creditor, date when it was incorporated, its identification number, and its registered office address, right? So this all information you have to give. Now in the next part, you are provided to provide for the corporate data. You have to provide the name of the corporate data, its CIN, its date of incorporation, registered office address, nominal share capital, paid up share capital, and memorandum of association. Now, as far as this is concerned, how you will go about it, the data you can get is from the MCA website, right? Then in the next part, as you move, right, you are required to give the name, email ID of the IRP and the consent of IRP which is to be provided. Then next part, you have to give the details of the financial debt. You have to tell them what is the total number of debt along with the date of disbursement of this debt. So these are some of the issues which you are required to follow. Now it is very important that the data that you give, right? Because these are a lot of numbers. So when you get your office to punch in those numbers, it has to be done in a very meticulous way, right? It cannot be just done simply. Carelessly, because there are recorded cases like that of a Bhushan stay, where it was with great difficulty the petition could be amended, right? So you have to file it in a very proper way. Then you have to, when you file these documents, right, you have to provide it in the triplet, right? You have to provide it in the electronic filing is the way it should be done. Then the scan should be legible, right? There should be OCR format. Then it should be given in a CD or pen drive as is required. Now the fee that you have to file as a financial creditor is 25,000 rupees, right? And in case of operational creditor, you are not required to file, you are not required to give a notice to the party, as we will see in the case of operational creditors. Now NCLT has a very limited role as to whether it can accept or reject the application. So it has to only see two things. First, there is a default, right? And second, there is no insolvency, this disciplinary proceedings against IRP. If these two things are there, then it does not have much of the ground to reject it. Now, earlier there was no provision to withdraw this IRP process once you have started, but by introduction of Section 12A, this IBC has allowed the withdrawal or application. The relevant regulation for that is Regulation 30A, and this application is made to the adjudicating authority. And it can be, when can you make this withdrawal application? This withdrawal application be made before or after the constitution of the committee of creditors. Now, when this withdrawal application is made before the constitution of committee of creditors, then application is moved by the applicant through IRP. But after the constitution of COC, it has to be moved through IRP or RP. However, if the interest of expression is already issued under Regulation 36A, then applicant has to give reasons justifying the withdrawal of such application that it has moved. Now, if you look into the rules provide that an application for withdrawal is to be made in form FA, and this should be accompanied by a bank guarantee. In case the withdrawal application is before the constitution of COC, then the bank guarantee is towards the estimated expenses incurred by the IRP. And if it is after the constitution of COC, then the estimated expenses occurred of the fee as well as out-of-pocket expenses paid to the authoritative representative, expenses incurred on or by the interim resolution professional, and approved expenses by resolution professional of the committee. Now, an application of withdrawal before the constitution of COC is filed by IRP. IRP must file this application of withdrawal within 3 days of receipt of the same. And if the COC is constituted, then COC is required to consider the filed application within 7 days of its receipt. The COC can approve the application of withdrawal only if it is approved by the 90% voting share of COC. In case it is approved by the 90% of voting share, then RP has to move adjudicating authority within 3 days of approval, right? So these are the things that you must remember. Now, once the application is admitted, 3 things happen. First, an IRP is appointed. Second, the moratorium is declared. And finally, you have this public announcement is made by way of advertisement for the initiation of CIRP against the corporate debtor. Now, the date on which the tribunal admits the petition, it is an important date. It is called the ICD or Insolvency Commencement date. Now, the time limit starts from this date. The directions are also issued to the Registry of Tribunal to communicate to the decision of corporate debtor and the financial creditor, and appointment of IRP is given to the IBBI. So they put it on their website as well. Now, as a consequence of allowing this application for initiation, so what does the tribunal do? The adjudicating authority, it orders, issues direction for appointment of interim professional. In the order itself, the adjudicating authority, it names the IRP, provides his email address, his registration number, right? And it also states that he has to carry the functions as mentioned in the code. So, in fact, the IRP becomes the de facto CEO of the corporate debtor, and the board of corporate debtor is temporarily suspended. So then, of course, you know that there is this period of moratorium and everything that is there. And in case it is moved by where there can be class of creditors, then the advertisement itself will contain the name of 3 IRPs, which the persons they can suggest that this person will be our IRP or our authorized representative. So initially, in cases where there were only operational creditors, right? So it was very difficult to judge them, that they need somebody who understands finance and law, who can decide that this is the case where the person should be appointed. So the IBBI started giving in the announcement only, the adjudicating authority, that these are the names of 3 IRP and you can pick one, and whosoever gets the highest number, that person is appointed. Thereafter, we move to the filing by operational creditors. Now, for the operational creditors, it is a very different procedure from that of the financial creditor. The relevant sections for filing as an operational creditors are section 8 and 9 of the IBC, and it has to be read in conjunction with Rule 5 of the adjudicating authority rules. Now, in case of operational creditors, what you have to do is you have to serve them a demand notice, and you need to give them 10 days of time, so that if they can say that there is already an existing dispute or they are willing to settle it, then you don't start the insolvency resolution process. Now, this is a statutory requirement which you are required to fulfill, right? So in this case, you must remember that the civil court will not have jurisdiction. So the problem that can be asked to you is that you are a young bright lawyer. There is one MNC which comes to say that they have provided goods to another MNC, and MNC is to pay the goods the money for the goods paid by the first of last month. Then they haven't done so. So then how you are going to file it? So first you have to ascertain that the default is of 1 CR, 1 crore rupees, and then you have to file a server demand notice. So as the operational creditor, your demand notice must be a detailed one. The reason is then this will become the very basis of filing your IBC application under section 9. So under section 8, you send a demand notice, you put the invoice receipt, and you show that how this debt has been incurred, right? Once that is done, what you have to do is you have to ensure that the debt is being paid by the parties, right? So you give them 10 days notice that please consider, and you are required to file that. Now, the format of demand notice is also given in the adjudicating authority rules. So, demand notice can be sent via Form 3 or Form 4, right? So, in one case, when you have invoices, right, and these invoices, what do they show? They show that there is an existence of operational debt. And the second situation is when you don't have any invoices. So in the first scenario, when you have the invoices, right, the adjudicating authority will simply send a notice in Form 4 of the adjudicating rules. So if you look at the Form 4, you have to give the authorized signatory has to give his address to the corporate debtor and give its registered address, and simply calls upon the corporate debtor to pay the operational debt that is due. Now, this is to be supported by the invoices of the operational creditor. Now, the more challenging part comes when you don't have the invoices. So, where operational debt is not by the simple means of invoices, it can be via means of charge on a property or a title. In that case, you have to serve the demand notice in Form 3. So, if you look at the Form 3 of the rules, what does Form 3 provide? That you have to give particulars of the operational debt. So you have to give how this amount has reached, since when it is due, for what purpose it is due, and you are required to show the computation of default in a tabular format. the rules itself provide that it must be in a tabular format, and then you can calculate the interest also. So again, the information you can always access from NCA's website, as I have explained you earlier also. Now, if you are retaining any title arrangement in respects of good to which the operational debt refers, then you are required to provide the details of the same. You are also required to furnish record of a default, if any is there, if it is filed with the information unit, this utility. Then finally, in the form, you have to give the list of documents which are attached to the application in order to prove that there is an existence of the operational debt. So then you give the 10 days time, and if the person, the corporate operational debtor, need to ask corporate debtor if he believes that operational debt has been repaid, he has to document it same way by attested copy of the record of the electronic transfer of unpaid amount from the bank of corporate debtor, or attested copy of any record that shows that the corporate debtor's debt has been repaid. So he cannot just simply say I have repaid. He has to also prove that the debt has been proved. Then this person is provided 10 days time of after receiving this demand notice. So you have to keep the tracking of the document, the notice that you send, and only after it is delivered, take the 10 days of the same. Now, so in this case, when you look at this, that when you are disputing, suppose you serve the notice and the other person, that he disputes this amount, right? So when you serve the notice, there are three possibilities. First is that corporate debtor, he disputes the debt, that he does not, this he does on the basis that the evidence which has been adduced by the way of pendency of suit or arbitration proceedings in relation to operational debt. So, and it was already in existence. That is, it was in existence before the demand notice was served. So, then in that case, you cannot invoke the jurisdiction under IBC, right? Then the second possibility is when the corporate debtor, he repays the debt and sends the operational creditor evidence of the electronic transfer of unpaid, then the matter ends then and there. And the third situation which the IBC code it envisages is that corporate debtor repays the debt and send the operational creditor an encashment of a check issued by corporate debtor towards the payment of the operational debt which is referred in the code. Then in that case, it will not proceed further. Now, how does CIRP initiates in the case of operational debt? So, now once the demand notice is sent by the corporate debtor and the debt still remains unpaid, what you have to do is you have to file the CIRP application. Now, at this juncture, what you have to do is you have to see who can issue the demand notice, and on that, it was initially in the code, it was provided that it can be sent by the operational creditor only. Later, it came to be said that it can be done by the authorized person. So it actually came in the case of Macquarie Bank versus Shilpi Cables, which said that if you are operational creditor's lawyer, you cannot do so. So NCLT and NCLAT upheld that, but Supreme Court reversed it, and they said that even a lawyer is an authorized representative, and he can also send the notice on behalf of the operational creditor. Now, in this case, it was a foreign entity which was an operational creditor, right? Now, as I have told you, for the financial creditors, they can move a joint application, but it cannot be done so in case of operational creditors. Each operational creditor has to stand on his own legs, saying that there is a default of 1 CR, and then he has to take this further, right? unlike the financial creditor. And as we have seen, the fee that you have to pay for the financial creditor is 25,000 rupees, but for the operational creditor, fee is only 2,000 rupees. Now, as for the filing procedure for filing, your demand notice will be the key document that will be used for filing the demands, which will be the key basis for making your petition. Now, as far as you have to file this petition, so you have to use the form 5, right? In the form 5, like form 1 was there for your financial creditor. Form 2 was for taking consent for IRP. Form 3 and 4 was for sending the demand notices, depending upon it is with invoice or it is without invoice. And finally, when we come to the form 5, you have to give the various details. So in the part 1 of the first part of your operational creditors, you have to provide the identification number of operational creditor. So many times operational creditors are individuals. So in that case, you can provide them their Aadhaar detail or their PAN card detail. Then in the part 2, or if it is a company, then of course you have to give it CIN or the of that company. In part 2, you have to give the details of the corporate data, just like you have to give the name, corporate identification number, date of incorporation, nominal share capital, and paid up capital. If there is any guarantee clause, and address of the registered office is to be provided. In the part 3, you have to give the details of IRP. Now, this is again slightly different from filing as a financial creditor. In case of financial creditor, it is mandatory to provide the details of the proposed interim resolution professional, but that is not so in case of operational creditor. You can leave it at the wisdom of the adjudicating authority, because many a times financial operational creditors are not aware about who will be the good IRP in this particular case. Then part 4 is very important, where you have to provide with the details regarding the operational debt. Now, these details you will take it from your demand notice itself, right? So the large chunk of work is done when you send the demand notice, because you already have all the details, right? So one thing you need to remember is there cannot be any discrepancy in the demand notice and the application you are filing for initiation of CIRP as operational creditors, right? So you have to fill the details of total amount of debt which is due, details of the transaction on account of which the debt is filed, and you have to specify the date from which the debt is due. And this all has to go in a tabular format. Amount you are claiming, the principal amount, as well as any interest that has been incurred, right? Then you have to give the details of the documents, the list of the documents you are relying upon to prove that these are the debt which is incurred against the party. Now, once this is the matter goes before the NCLT, the petition is filed, right? So for the operational debtor, the rule 6, right, provides that an operational creditor is required to dispatch a copy of the application filed under section 9 to the registered office of the corporate debtor, right? And you will also recall that already you have sent him a demand notice, which was sent 10 days before the service of the has to elapse before this application can be filed. Now, for the adjudicating authority, it has to accept the application if it is complete in all respect. If there has been no repayment of the operational debt in respect of which the application has been filed, if the invoice or demand notice of operational creditor has been delivered to the corporate debtor, if it crosses the threshold of 1 CR, and there is no disciplinary proceedings which are pending against the proposed IRP, then in that case, you have to, the adjudicating authority has to admit this petition. Then all the three step appointment of IRP, moratorium, and your, what do you call this, public announcement will be done. So the key case in this is Mobilex versus Curiosa, which talks about how should an operational creditor's application is to be dealt. Now, very often these applications are rejected, and these are rejected if it is incomplete, right? So, if the tribunal is going to reject it, it has to give an opportunity to the operational creditor to rectify the error. So, it is given 7 days to rectify the error, right? So actually the issue arose in JK Jute Mills. They said that whether this period of 7 days is mandatory or it is just a guiding principle which is there. So court said that it is not mandatory per se, but try to finish it within in 7 days. So these are two types of operational petitions that can be filed that we have covered. And let me just share with you the third one also, which is by corporate applicant. Now, in this, the first thing that we have to look upon is who is a corporate applicant, right? So, like if you look at the winding up, earlier it was under the Companies Act, right? Today, majority of winding up is done only under the IBC. Right? Virtually winding up has become the voluntary winding up. If it is being directed by court, then it will go before the High Court under the Companies Act. Otherwise, the winding up is done under the this IBC only. Now, there are many reasons that a person would like to declare itself as an insolvent. So there can be large reason that person does not want to continue, or he thinks that better way is to get out of this and take a haircut and probably start a new business because you are not able to fulfill this amount. Now, the definition of corporate applicant is given under subsection 5, subclause 5 of the Act. And under this, a corporate applicant can be a corporate debtor, the company which is under the distress. It can be a partner or a member who is authorized under the constitution of the corporate debtor. He can also move. A person who is managing the operations of the corporate debtor, and the person who has the power of control and supervision over the finances of corporate debtor. He can move the adjudicating authority to.
Charu ma'am, one small request. If you can actually put it in presentation mode and keep scrolling, because we are seeing only the first slide. I'm sure you must be speaking out from the other slides.
Yeah, 1 minute. I'll just 1 second. Actually, one is in. Now you have to file this application where the NCLT's registered address of the corporate debtor is there, right? You have to file it there, and for this again you have the fee of 25,000 rupees which you have to pay, and you have to file the filing proof for the same. Now, what all do you need to include in this? The name of the proposed IRP, what is the financial condition of the company, right, which is going under this process of voluntary winding up as a corporate applicant, and the authorization resolution is to be there, right? So all these things which are covered under section 10 of IBC, they are to be covered. Then when the matter goes before NCLT, they have to verify first that it is complete in all respect, and the timeline for decision is 14 days from the date of filing. But in practice, it is not always followed this practice of this timeline of 14 days. Now again you have the same procedure is there. You have to appoint the IRP who becomes the de facto CEO of the company, and then he is the person who will look into the operations of the of this thing, the corporate debtor which has chosen to go into the voluntary insolvency. And the key case that you must read is the one of the earliest cases that we had on this thing, insolvency, that is by Justice Nariman, Innovative Industries versus ICICI Limited. And then again the same process is there. You invite for the claims, take over the assets, collect all the data, invite the resolution plan, propose, you make them information memorandum is there, it is shared. The parties, if there is somebody willing to take it over, it is fine. Otherwise, you liquidate the company, and whatever is there as per the waterfall mechanism, you distribute. So these are some of the processes which are there. So this is all that I have to share regarding how do you file it. But the most important thing regarding the filing is the how meticulously you have to fill in the numbers, because many times when you are punching the numbers, right, sometimes instead of your 7 you enter 1, right, on your keyboard. So this is one thing which has to be tested again and again, to be checked again and again repeatedly, because the procedure to amend that petition itself is very tedious, right? And if you have any queries for me, I am open for that.
Good evening, ma'am.
Good evening.
Do you happen to have a sample draft that you can show us? It will give us an idea of how it actually looks, because I'm not sure if one is available on the course.
Okay, 1 minute. Let me just 1 minute. I'll open one of my files and I can show you actually. 1 minute. Let me just take out. Okay, I'll show one of the claims that I had filed. So all of you are lawyers?
I have been practicing for about a year, ma'am.
Okay, where are you practicing?
I practice in Delhi. I also met you in the Supreme Court twice.
Okay. So this is one claim which we had filed. We were for this Commercial Tax Department of Rajasthan, and this is for the operational creditors that we had filed. So I'll just scroll through this. So this is the Form C. It used to be, this is 2020. And in this you have to file, this is the format, which is the form given. So you take it in the Word document so that you can type it properly. The name of the operational creditor, if it is an incorporated body. So in my case, it was Government of Rajasthan Commercial Tax Office, Kota. Address for correspondence and email ID I have given. Then the total amount of claim, including the interest which is there. So total of tax which is due, total of interest, and total claim which we have written. So this is before COVID. I think this is before. And details, how do I reach to this conclusion? So these are type of the act. It is under the Central Sales Tax, VAT, CST, date of order, period, tax and amount, and total amount. So all these details are there. Details of any dispute as well as the record of pendency of suit or arbitration, none was there. And then how the debt is incurred. So here I have said that it is mentioned in the point 4 and the list is enclosed, because I cannot put possibly everything here. Then details of any mutual credit etc., which was nil in my case. Any documents, any title is relinquished. So all these things you keep on filing. Then the details of bank account in which it has to be transmitted. So it has to go, State of Rajasthan, it has to go under the VAT head, this, and under CST head, this they have to give. Then who is the person who was authorized to do so? The name of that person, the advocate, the person whose affidavit who is filing this, that has to be there. And here you have to provide the assessment document, the documents that you are relying upon. So there is an assessment order, there is details of due demand, various demand notice sent by the email, and then it has to be attested by the person. It has to be verified also. Then you keep on attaching these documents where you can show the details how the debt has been incurred. So these are all the details which you have to provide. So these are just the demand notices that you have sent. And then you have to email it to the person who is the IRP, RP or liquidator as the case may be. So these are some of the things. Some other drafts also. Let me see if I can show you. The screen is frozen. So these are some of the formats. So anyways, like if you have any queries up till now, you may please ask. Any queries? No? No, Shruti. Mr. Lakshminarayan? Mr. Rahman?
None as such, ma'am.
Okay, then thank you so much. Have a great weekend, I can say now. Happy Sunday, I can say. It's a Saturday today.
Thank you, ma'am. You too.
Ma'am.